Welcome everyone, thank you for joining us. If this is your first time attending one of these talks and you're not familiar with Cambridge CARES, we're the University of Cambridge's research centre at CREATE in Singapore. So we've been going since 2013 and our work is mainly related to decarbonising Singapore's chemical industry. So yeah, it's my pleasure to introduce today's speaker, Joy Haughton. So many of you will know Joy as she's the Chief of Staff here at CARES. She joined CARES when it started in 2013 and since then has been responsible for the administrative ramp up and management of the CARES program. So now she manages a team of 12 and we're all based between the UK and Singapore. So today Joy will give us an overview of the patent process for academic researchers, and I'm sure there will be lots of time for questions and answers afterwards as well. So feel free to post questions in the chat or just to ask when Joy's finished her talk. So yeah, Joy, over to you. Thank you very much.
Great, thanks Louise, and thank you Nick for the invitation. The title is maybe a little ambitious. I'm going to do my best to give a quick overview. Obviously, we've not got 3 days to run through every possible aspect of patents, and it is a complicated area. So I'm going to try and give you just the top points that for academic researchers in a centre like CARES, I know some of you are not CARES researchers, but I think most of you are in academia, are the things that when I deal with helping researchers to commercialise their work or attempt to commercialise their work, these are usually the things that trip people up or that people aren't aware of and don't know. So we'll dive in, but do shout if there's questions as we go along. I'm happy to deal with questions as we go or save them to the end if preferred. Either is fine. Just as a starting point, I'm assuming that most of you work in academic research, you moving along with your research. At some point you may, or perhaps you already have done, come across something possibly that you think might be a commercial prospect. It's probably, when you first come across it, going to be something really a seed of an idea. It won't be probably at that point anything close to what would actually form a business in the end, but that's fine. That's exactly what we might expect in academia, and that's still well worth starting to explore with the resources that I'll go through with you, what you could do with that if you're interested to do so. So at that little germ of an idea stage, or even before that actually, it's useful to be aware in any of your academic work that might be commercializable, some of these points that I've popped there on the slide, because these are things that affect how you can commercialize pieces of work and how attractive that might be to you as a researcher. So the money that you're using and the resources that you're using to do your work, and that might be the money that's paying you, it might be the money that's paying for the consumables you're using, it might be the money that's paying for the equipment you're using, it could be various different sources, and you may or may not know exactly where that's come from, so we'll go through in a minute how to find that out if you're not sure. That money usually has terms attached to it, and that might be, if it's come from the public sector, they might be fairly gentle terms. If it's come from industry, they might be quite strict terms on IP. So that's a good first thing to be aware of. Also, who's been involved and what the employment contracts or the contractual state of those people are. So, for example, in CARES, we have researchers who are employed by CARES directly. We have researchers that are employed by University of Cambridge. We have researchers employed by NTU and researchers employed by NUS. And all those people have slightly different employment terms and employment contracts in terms of how their IP is handled. So it's again worth being aware, and if you're not sure, we'll go through who you can ask about that. Then also the other one that sometimes trips people up a little bit is being aware of what you've used in developing your idea. It might be you've used some materials that you've got from industry, perhaps some samples. It might be that you've used some commercial software in a very integrated way in your, particularly if you've developed some code, that might be the case. You may have used some background IP from somewhere else. So again, all of those things may well have contracts associated with them that will affect how your idea can then go on and be commercialized. So that's a good first set of things to kind of pull together when you're starting to think about. As you go on in your academic careers, or if you go into industry, if you're pulling in money yourself, if, for example, you get to be a faculty member and you're pulling in grants yourself, it is worth being aware of the different terms on these grants, because some are much easier to commercialize off than others. So you may decide to, if you've got the tiniest speck of an idea that might be commercializable, it's worth considering which is the easiest source of funds, and which will make the most sense in terms of commercializing, if you have a choice. Obviously, as a postdoc, you may not have a choice. So it might just be a case of figuring out what the lay of the land is based on what you've been given. So if you don't know the answer to these kind of things, how can you find out? Well, first sources of help, your PI, your principal investigator, if you're a postdoc, will be a great source of help. They will likely have been involved in agreeing the terms for the money you're using, and so they're likely to have a good idea on that. Your grant administrator, or somebody like me. A little bit further down the line, your University Technology Transfer Office can also help, particularly on employment policies and that sort of thing for your institution. You may also find that your institution has some training and development programs that can help you with the more general sort of background that you might need. For example, in Singapore, the Smart Innovation Centre has some programs. There's the Lean Launchpad program, which NUS and NTU joined together on, and Cambridge Enterprise in Cambridge also has a free webinar series, which I think actually anybody can join. So those are all worth watching out for, because they can also give you some good background. So when you're talking to those people, what you're trying to get together is those documents that we just talked about. You're trying to get an idea of what your basic foundation starting point is, what your constraints are. So it's essentially a map of what you can and possibly can't do in terms of commercializing this particular idea that's emerged from a particular set of circumstances and from you as a particular group of individuals with a particular set of employment contracts. And it's worth bearing in mind, not all of you in a group of inventors may have the same employment contracts and terms and constraints on you. So if one person is funded from a different source than others, that can also add its own complications. So make sure that you're talking to your fellow inventors as well. So then, looking at this little germ of an idea, how do we know what might be patentable? Now, the patent law does vary around the world, but it does have a lot of commonalities in the different countries around the world. So these three bullet points here are pretty common in most patent laws in different jurisdictions around the world. Certainly UK and Singapore both apply these. US also applies these principles. So they're fairly universal. And they give us a good filter for, is this an idea that's worth exploring in this context? Absolutely not. Is this an idea worth exploring scientifically? That's a completely different question. And it's worth emphasizing that things that are worth exploring scientifically may well not be patentable, and that doesn't affect their worthwhileness in terms of you as a scientific researcher exploring them. It doesn't mean that you shouldn't be working on that. That's a question for you and your PI to look at what's worth working on. This is purely about what might be patentable. First one, it's got to be new, and that means it has not publicly been disclosed anywhere in the world. And this can be a real stumbling block. It sounds quite easy and obvious, but this is something where, for example, if you've already talked about the idea in a paper, you've talked about it in a conference presentation, you've even, technically, if you've talked about it in an email to a friend or something, and you haven't applied a non-disclosure agreement to that, theoretically, that could mean that it's not patentable. Obviously, there needs to be there would need to be evidence that they had been disclosed. So if it hasn't been disclosed in writing and you've only disclosed it to your mum or something, you're probably all right. It's probably still worth exploring, but it is worth being very careful with that sort of thing. The way, if you do need to talk about it to others, because obviously you may well do, the way to do that is to make sure that there is a confidentiality agreement between the two of you before you start discussing it with somebody. So well worth, before you make any kind of public disclosure, talking to the tech transfer office, which we'll come on to in a minute, how you do that, just to make sure that you've kept all your options open before you make any kind of public disclosure. The second thing it's got to do is be what's called an inventive step. So it's got to be a real improvement over any existing product or process, and not obvious, not just a what's called an incremental. So if it's too similar to something that already exists and that's on the market, then that will be considered not enough of a difference to be worth an extra patent being issued. So it's got to be something really different, and the tech transfer offices can help with whether something would count really as an inventive step or not. Then the final one, which can be quite challenging in academia, is that it must have real industrial application. It must be something that somebody could have a business doing or making or selling. And it may be that it's an add-on to an existing business. It may be that it's in a whole new business in its own right, but it does need to be industrial. So something like a new theory about the structure of a particular substance probably could be challenging on that front, unless there's a real industrial application, which there might well be. So things like scientific theories aren't patentable. There's actually quite a lot of exceptions, things like surgeries, methods of surgery on humans and animals are not patentable. Even there are also some exceptions to do with what might be called, I suppose, moral exclusions. Things like weapons. The UK, for example, excludes patents on, will not issue patents on cluster bombs. So there's various different things that can't be patented, but if in doubt, it's well worth asking, and depending on what your particular idea is, that can be you can get some help on that. Software is worth mentioning. It is a very, very specific area of protection. Usually software is difficult to patent, but it might be possible to do what's called copyright it. but it's, again, it's something that needs looking. You would probably need to have a proper discussion with the tech transfer office if you've developed some software that you think might be commercializable, because it can be protected, but it's often not a patent that would be issued. So that's so what's patentable? It is a complicated area, it has to be said. There are armies and armies of patent lawyers, patent advisors who help to apply this area of law, which is complicated and does differ slightly in different places what exactly can be patented. So it's worth having a proper discussion about your specific idea. That hopefully gives you a bit of an idea of the first filter that would be applied. So again, I touched on this earlier. Not having a patent doesn't mean that you can't have commercial success with an idea, and having a patent doesn't mean that commercial success is guaranteed. In fact, only about 2 to 3% of the patents that are granted worldwide actually ever come to market as a product. So it's definitely not that you get a patent and immediately worldwide success and riches are all yours. It's quite a specific set of circumstances that a patent is useful for, which we'll go into a little bit in a moment. So what does a patent mean? It basically just means, as I've said there, you hold the exclusive right to use or to give permission to use your invention in a particular region of the world. So if somebody else wants to use that invention, they would need to get your permission. And if they try to use it without your permission, the law is on your side if you can afford to ask the law to be on your side by bringing a case. So that's it's not that automatically the law would prosecute anybody who tried to use your patent. You need to be willing to defend that patent, and that's something that also can surprise people sometimes. That it's not an automatic protection, and there is a lot of effort that goes in by commercial companies to trying to find ways to sidestep patents that may have been granted, and to race to obtain protection in areas where perhaps they weren't actually the first to come up with the idea. So it's something that can be a bit cutthroat, and it's well worth bearing in mind. Patents are very much more relevant in some markets and some business models than others. So it's worth taking the time on your particular idea to think about what your business model might be, what your market might be, and to discuss with people who are expert in that particular area, in that particular business market, before you get too locked into the idea of patent. It may be that for your particular market, a patent isn't the most appropriate form of protection, or indeed that protection is not the most appropriate idea for your business model. It can be that getting to market as quickly as possible in some industries without waiting for protection can be the most appropriate way to go about things, and the most the best chance of success. So worth a discussion. The patents again, in terms of good sides of them, we've gone through a lot there on what can be difficult about patents. They can be a really big credibility step in some industries. They can be part of the picture in securing next step funding as you try and develop your idea further and to get it closer to commercialization. They can help to generate momentum in your business planning and to access further help for an invention. And they can, for in some academic careers, they can be a career boost and sometimes popular with funders, which can give you access not just to commercialization funding, but also to further academic funding. So there's pros and cons. Sorry, my computer is just having a little meltdown. So if you decide you think you might have something, what might you do next? So you've got this little germ of an idea. You've got together your set of documents. You kind of know the lay of the land in terms of what constraints are on you and your co-inventors. You've talked to everybody potentially involved with the invention, and together you've decided you want to try and explore what the options might be. So in an academic institution, usually your first step there would be to fill out a technology disclosure form, which would go to your tech transfer office. In the case of CARES, for anybody CARES listening, our tech transfer office is actually Intuitive, the NTU tech transfer office, which is the result, as we were talking about earlier, of our grant terms for most of our major grants. So that's because we've got public sector grants, Singapore government grants, as most of our major grants, and the Singapore government decided that they wanted to pass a lot of the management of our IP through Intuitive. So it might seem a bit odd, but it's a good example of where things can be a bit surprising in the grant terms sometimes. So if you're not sure how to get hold of a copy of the technology disclosure form, your tech transfer office will certainly be able to give you one. If you're in CARES, you can get in touch with myself or Louise and we'll be able to give you one. And once you've got hold of that form, there's a whole bunch of questions on there. Now, a lot of researchers get a bit stalled at that point and a bit terrified by the amount that they need to be able to write down. It's still worth, if you really think that you've got something, it's still worth filling out what you can of that form, because the form looks a bit overwhelming perhaps, but what will happen as soon as you've filled out that form is that somebody from the tech transfer office will have a bit more of a conversation with you about it, and those details can be filled in later. They're not all essential for that first step. They will be essential before very much can happen in terms of actual patent applications and things, but for the very, very first stage, don't be put off from making a technology disclosure because you don't know all the answers on the form. Put it in, and there's plenty of people who can help you if you're not sure. So eventually, what you need is a description of what's being disclosed, and that description is not an academic abstract. Very, very often what we see when researchers try to fill in a tech disclosure form is we'll get sort of what would be an absolutely beautiful, well-written abstract for an academic paper. That is not what's needed. What's needed is something that references back to that list of 3 key items: the novelty, the inventive step, and the industrial application. So that's why that list of 3 aspects is really, really important to bear in mind, because you will, from the very first steps to trying to commercialize particularly via a patent route in universities, you will need to be talking about it in terms of those steps. You will need to be listing down who's been involved in the invention. So again, that's not quite the same as co-authors on an academic paper. That's somebody who's really had an intellectual contribution to the invention itself. So someone who's perhaps a research assistant who's just done what you've told them to do and produced some results. That person is unlikely to be an inventor if they haven't contributed intellectually. So they might perhaps be considered as a co-author on an academic paper, but not an inventor. If you're not sure, it's fine to again put down everybody, and the tech transfer office can help you to work through who's actually made an intellectual contribution. As we've mentioned, where the funds for the research have come from is very, very important. So do make sure that you've got your grant terms before you fill out the form. And again, if you're not sure, that list of people that we talked about in the beginning, they can help you with that. As we mentioned earlier, what else is essential to the invention? The background IP, the other software, external materials, etc. that you've used for it. Also very important to put down on that form. The Tech Transfer Office will also want to know how far you've got with this invention. Is it just an idea? Is it something that you've got some evidence for? Is it something you've got a prototype for? Is it something that you've even done some actual testing of the prototype? All of those are fine, but they will take different routes depending on how far along you are. They will also need to know about any planned public disclosures, and obviously if you have already disclosed publicly, as we've said, that will close down some of the options available, so that they will also need to know about. It probably is worth saying, because it is a mistake I've come across occasionally. Sometimes researchers fill out these tech disclosure forms and they think it's better not to say if they've already given a conference paper on it. It's not. You'll just waste a lot of time because it will almost certainly be found out at some point during the examination process if you are applying for a patent. So much better to say. Usually what the tech transfer offices can do at that point is to help you to look at whether you can patent another element that hasn't been publicly disclosed, or it may be that what you disclosed isn't as significant as you think it is in the patenting process. So do just tell them, write it down on the form, and much easier than it popping up later. Then, as we've talked about, the industrial application of an invention is very important in this process. So do make sure that if you are aware of any possible commercial interests, even if you haven't explored them yet, even if you've had no conversations, list those down. You don't need a comprehensive list at this stage, but even just an idea that there's potential areas of industry that this could be useful to is very helpful. Touched on a few of these, but these are a list of some of the things that kind of trip people up a little bit sometimes in this technology disclosure phase. So as I've said, public disclosure can create some constraints, and that's why it is always worth, if you're talking about your work, particularly with industry, it's worth inquiring whether an NDA might be a good idea, because that can then protect you later on in a patent process, because you're then not considered to have disclosed publicly. If you don't have an NDA in place, that may well be considered a public presentation if you've presented outside of your organisation. Internal presentations are usually not a problem. Academic researchers can sometimes find that industry awareness is a bit of a challenge. So if you get the opportunity to involve yourself in networking events with industry, with professional groups, any chances you get. If you are interested in commercialization opportunities, all of that contact with industry is really, really helpful. And even if it's not directly relevant to your particular invention that you're working on at a time, it gives you good contacts, it gives you an awareness of what kind of problems industry might be working on, and how you might fit into that with your invention. It's worth thinking from a very early stage about how this invention might be made to make money, a business plan. It's not something that every academic researcher wants to think about, but if it's not something that interests you at all, then it might be that you're not the right person to commercialize this. That doesn't mean you can't put in a technology disclosure form. You can. But if you're not really interested in the industrial application of your idea, you might find that you waste quite a lot of time on something that maybe isn't quite right for you. You're not usually, in most cases, you're not under any obligation to take forward a commercialization process yourself. You may, depending on your employment contract, be under an obligation to put in a technology disclosure form, but you're certainly not obliged to commercialize. So in universities usually. So if business plan makes you feel a bit weak at the knees, and it's not just a lack of knowledge, it's really you're not interested, that might be a sign that perhaps you might be better focusing your energies elsewhere. So do bear that in mind. Another thing we come across quite frequently with academic researchers is this idea of, I just want a patent. I don't really want to do anything else. I just want a patent to my name. That is, it's doable, and I have seen people do it. Just put it in just to get a patent. What you probably will get in that case is what we'll come on to later. A provisional patent application you might well get. A full patent application, you're unlikely to convince them if you're just in it just to get a patent to your name, because they're more expensive. And it does take a lot of your time and energy. Some of you here, I know, have put in patent applications and even been granted patents. And I think those who've done that will definitely attest that it is very time consuming, both for you and for others. So do bear that in mind. If it's just a case of I just want a patent, there might be other ways to achieve your career goals. They're a little bit easier. As I said, don't just copy and paste from things prepared for an academic audience. Do think about those key 3 things that a patent examiner and a technology transfer office will be looking for. Do discuss with other inventors. It sounds like a surprising one, but we have occasionally had tech transfer forms come in that really people haven't talked about it among their group, and that can be a little bit problematic. So if you know that somebody else has had an intellectual input to an invention, you do need to talk to them about it before you put in a tech transfer form. Don't have it be a surprise. Don't try and hide that other people were involved. It's not worth it. It will come out later. The grant terms, we've talked about. Do make sure you understand those. The other one that does come up quite a lot is expecting that the tech transfer office will completely take over doing all the business stuff, and you will just be able to carry on being an academic researcher and not have to really do anything businessy at all. This one links back with the business planning part of it. That's not the case. They will give you a lot of input and support, and they have a lot of expertise that can be useful. But it is absolutely not the case that they will do everything for you. You will need to be willing to and have an interest in doing quite a lot of investigation into the industrial applications. You'll need to be willing to go and talk to potential licensees in industry. come up with business plans, put yourself out there to get funding, all of that. If that's not something that appeals to you, you may be able to find another colleague who is interested in doing that, who's perhaps been a co-inventor. That can be a good solution. But if you really don't have anybody on your team who is interested in that, again, this may not be the best use of your time and energy, because you will need to be doing some of that. Okay, so then a slight tangent, but an important tangent, because this one confuses people a lot. So this is the difference between an inventor and an IP owner. So this will be different depending on your employment contracts. So an inventor is always the person or the people who've made an intellectual contribution to the invention. And as we've said, that might not be the same as a co-author on an academic paper. If you've got multiple people who've made an intellectual contribution to your invention, you will need to decide between you and agree what percentage input each person had. And that can be very easy, it can be very difficult, and it is ultimately up to the group of inventors. The Tech Transfer Office won't decide that for you. You will need to come to an agreement between you what percentage of each put in. Then the owners of the intellectual property, that might be the inventor. In an academic context, it's more likely to be the employing institution of the inventor or inventors. It could be the sponsor. For example, an industrial sponsor is very likely, very, very often will claim ownership of the IP that they've sponsored the production of. In some cases, it might be the government. There's all sorts of possible options. So that's, again, why your grant terms and your employment contract are very important documents in understanding what your situation is, what your rights are, because as an inventor, it may well be that if you're not the IP owner, the IP owner offers you some incentive to invent things. So that might well be that you get a split of any license income, or a split of any ownership rights over businesses that may be set up as a result. There's all sorts of different combinations, and if you're in CARES and you're not sure what applies to you, you're very welcome to come and have a chat. But your employment contract should lay that out for you in combination with your grant terms. But well worth checking into, so you understand what you're going into, because we do sometimes have people who think that they are going to own all the IP that they've come up with, and then they find out that they've signed something that makes that absolutely not the case. Just because you don't own it doesn't mean you won't ever make any money from it. As I said, very often there will be some incentives for inventors in most cases, that depends on the institution that owns the IP. Okay, so pitfalls aside, once you've submitted that tech transfer form, what happens next? So usually the group of inventors, once they've submitted that form, will have a discussion with the lead tech transfer office. So this would be, might be the tech transfer office of the majority of the inventors. It might be the tech transfer office named in the grant terms as the lead tech transfer office. It could be the only tech transfer office involved, but the tech transfer offices will usually know who will be leading these discussions. They may have to involve other tech transfer offices if you have inventors from multiple institutions. So you might have, I know some people here, Nick, for example, has had inventions where there's been 3, 4 institutions involved, so we've got multiple tech transfer offices. So that can get a little bit complicated, but usually the tech transfer offices are very experienced at pulling all of this together. So normally they will know who should be being contacted. If that seems not to be the case, certainly if you're in CARES, you can always come and let me know, and I will help you to navigate the the jungle, if there's a bit of a jungle developing. Then, once they've had a discussion with the inventors, there may be points of clarification. They may help you to work up the tech transfer, tech disclosure form a little bit, so that it's a little bit clearer what stage you're at, what exactly it is that you're disclosing, any points of clarification on the terms, etc. Eventually, once that's all clear and it's in the best state it possibly can be, then the Tech Transfer Office will put that forward for consideration by a review committee. And that review committee will usually give some recommendations to the IP owners on the next step. The inventors, in almost all cases, will be involved in that recommendation, so they will also receive notification on that recommendation. And that recommendation can be one of a number of things. So in blue there, you've got, they might recommend that a provisional patent application or indeed a full patent application if it's very well developed, or another form of protection is applied for. They might recommend co-development. For example, if you have an industry grant, this might be something that's co-developed together with the industry. They might recommend retaining what you have as background know-how for. Could still be licensed out to third parties, but perhaps not suitable for protection. Or they might recommend that it's a bit early stage and it needs a bit more work to really decide what's the best route for it at that point. Usually the recommendation will be fairly clear. If it's not clear to you as an inventor, it is absolutely fine to ask for further meeting, further clarification. If you're not clear what you need to do and you're really keen to carry on and try and commercialise, it's well worth having some further discussions with the Tech Transfer Office. You don't need to just accept their first attempt at communicating with you if it's not clear to you. Okay, so given that Nick's asked me to focus on patents today, we'll focus on the bit in that list of possible recommendations, which is to do with applying for a patent. So the usual recommendation would be that a provisional or non-drafted patent application is made at this stage. This isn't possible in all jurisdictions, but it is possible in Singapore and it is possible in the UK and in the US. So, and it's called different things in different places, but it's basically, you're not actually applying for a patent at this stage. What you're applying for is a place in the patent queue and a date at which you've given your first indication to the patent authority that you have an idea. And this can be very important later because that date, then if there's somebody else elsewhere in the world who's applying for a similar patent that would cross over with yours, and they disclose their idea to a patent authority slightly later, your first date where you first got in the queue can be used to show prior art, as it's called, that you probably had the idea first. So it's effectively getting a ticket to sit in the queue, and you can sit in the queue for up to 12 months. In Singapore and in the UK, most jurisdictions that I know, you can sit in the queue for up to 12 months. You hold no patent, there's no protection during those 12 months, but you're not considered to have disclosed publicly. So you also, as long as you're careful, there's no particular reason why you would need to try and defend your idea at that stage. If you're going through your tech transfer office, during those 12 months, what they would usually be expecting you to do is to gather the evidence needed to make the case for the full patent application towards the end of those 12 months. So again, back to those three factors, it's the novelty, the inventive step, and the industrial application. And the Tech Transfer Office, when they feed back to you on the recommendation of the committee, will usually give you some idea as to where the weaknesses are in your current case and where you might need to build more evidence in order to be able to put in a full application at the end of the 12 months. The provisional application is very cheap. We'll come on to costs later. The full application is much, much more expensive. So tech transfer offices tend to be very happy to put in a provisional application to get a place in the queue. They are much more, they need much more evidence in order to be willing to put in a full application. So if you really want to put in a full application, using that 12 months very, very carefully, really making sure that you're directing your energies towards the things that are felt to be weaknesses in the case is very important. We see quite a lot of cases where researchers put in their provisional application and then sort of go off the boil a bit on the idea and get to the end of the 12 months and it's gone really quickly and they had a few other things to concentrate on and actually not nearly enough has happened to really make that full application viable option. And that can be a bit disappointing for people at that stage. So it's well worth having some conversations with the tech transfer office, really making sure you fully understand what you should use that 12 months for. And if in doubt, those three factors, the novelty, the inventive step, and the industrial application are going to be the ones to concentrate on. During that 12 months, there's a few things in addition to building that evidence base that are useful to think about that in many, many cases the tech transfer offices will ask people to start thinking about. So you will need to think about which markets or legal jurisdictions really, but markets is the business way to think about it, you would be wanting to apply for protection in. So a patent is not, you don't apply for a global patent, you apply for patents in particular legal regions, usually countries. And there is ways to do that so that you don't have to make an application in every country that you need protection, but you do need to be considering what your business plan says are the areas that need protection, because each regional area will usually have a cost associated with it for a full patent application. So it may be that your particular invention is particularly relevant to an industry that's particularly prevalent in the US and really basically unknown in Southeast Asia, in which case you're probably looking at a US patent and you might come later to Southeast Asian patents, but probably not immediately. It may also be that there's areas of the world where your particular invention would be more likely to, people would be more likely to try and copy it. And again, that might lead to some decisions about where to protect. So it's well worth, again, talking carefully with the tech transfer offices, getting their advice, what markets you might consider. They eventually would be the ones for an academic based invention. They would be the ones making the decision on which markets to apply for, but again, it's very much with your input, so worth raising that question with them. Worth thinking about how, during that 12 months, how are you going to fund further development work on this particular invention. Usually you're not market ready at the point at which you make a technology disclosure form. So it may well be that you want to be applying for commercialization funding. There's all sorts of different step-up fundings. You may be wanting to develop some co-development deals with industry. And again, through all of this, it's worth thinking about that non-disclosure element. Be careful not to do anything that would breach the public disclosure aspect. Don't be paranoid about it, but just make sure that things are marked confidential, that you've put in place non-disclosure agreements where they're needed. That funding for future development work can be important because it can, if you're still developing the IP, which you might well be, that can affect the ownership of the future portions of IP, which can be then significant in how you can develop your business or your licensing arrangements in the future. So again, very, very worth becoming familiar with the contract terms of any funding that you're applying for or considering. Business plan, as we've talked about, this is a great time to start familiarizing yourself with how business plans work, even if you don't want to start the business. If it's more of a licensing kind of model, very, very worth starting to access some of that training that might be available in your institutions, all the stuff available on the internet. We've got some things on the CARES intranet, resources and things available to help you learn a bit more about how business planning works. We won't go into it now because definitely haven't got time, but worth using that time to become familiar with that, particularly for the particular type of IP that you're looking at. Then IP ownership is also well worth thinking about a plan for. As we've talked about, your IP owners for IP that you might have developed in an academic setting may well not be you. And may change depending on what future funding you take. There are options often with universities to at some point buy back IP, which may affect your business plan. So it's worth understanding what your IP ownership options are. Sometimes you can put in for funding to transfer IP, to buy back IP. All of these things are worth discussing and quite specific to particular circumstances. So again, I won't go into details, but do ask about it. Look into potential licensees. They can be extremely important, and don't forget NDAs. And do, as we've said, make sure that you're really clear what evidence you are going to need to be able to proceed to a full filing, if that's what you want to do. So you get to the end of the 12 months, you've hopefully done lots of development work, and you are at the stage where a decision is being made about whether to go for a full filing. As I said, it is much more expensive and time consuming. So, and once a full patent is granted, there is maintenance effort and money required to keep up a full patent. So tech transfer offices are a bit more shy of going to a full filing. They go if they've really seen evidence that this is likely to be to have a real chance of commercial success. So some researchers do find it a bit upsetting if they get to a full filing decision and it's decided not to proceed to full filing. The question here is that the tech transfer offices are asking is absolutely not, is this good science? Absolutely and completely not. It might be fantastic science, but it's not got enough of a chance of commercial success given what they're seeing in terms of the case that's been built. So don't, if that's you, if you get to full filing decision and it doesn't go to proceed, then please don't take that as a comment on your science. it's much more likely to be a comment on the business side of things. So that's why it's well worth getting yourself up to speed with that business side and industrial application during that 12-month period of the provisional. If it doesn't go to full filing, that absolutely does not mean it can't be commercialized. There's lots of other options still. As we said earlier in the talk, patents are only one option for proceeding to commercialize something. They're not even the best option in some cases. So it absolutely does not mean that you can't start a business. It doesn't mean you can't license something. It just means that particular protection route the Tech Transfer Office feels isn't appropriate this time. So this gives you just a bit of an idea how long that after that provisional application is filed, what then happens next. So if you do go to full filing, that's the point at which there may be, so this PCT is a process by which patent applicants can apply for multiple patents around the world at the same time in different jurisdictions. Makes it a little bit easier, less admin heavy. However, this full process does take 2 to 4 years. So it's not a quick process. It's quite time consuming for the inventors. There's quite a lot of queries usually along the way that you need to respond to, both from the tech transfer offices and once it gets into the full application from the examiners. So do go into it with your eyes wide open. If it's something that you really want to do and if it really fits with your business plan, it can be very, very worth doing. But it's not a light process. If you get to the point of having a patent granted, then that protection can last 20 years. So it's, again, not forever. Some people sort of come in thinking that once they've got a patent, it's a forever thing. It's not a forever thing. It's 20 years maximum. So just to finish up, I just want to give you a little bit of an idea of fees. So that first provisional application to hold a place in the queue, that's about 1,000 Sing. So pretty small, and usually the money can be found from somewhere. The full application is much more expensive, and if granted, then there is maintenance fees, usually from year 5, through the full lifetime of the patent. Also consider patent defense costs. The only point of having a patent to some extent is to be able to protect your invention. So if people try and steal it, you may well need to protect it in court, and that also has costs associated with it. So just to give you an idea why, in money terms, particular decisions may have to be made on viability. Again, something that sometimes confuses inventors in the academic world. What you can do if you don't agree with the tech transfer offices at any point, the decision does lie with them for spending the university's money or grant money on protecting inventions. They often will represent the universities as IP owners, so they also have some decision-making power on that front. So you won't have power of veto over their decisions, but there usually are some get-out points where you as an inventor, if you want to, if you disagree with how they're handling it, you want to have them hand back IP to you. Many universities do offer that option to inventors. It's not for the faint-hearted, it has to be said, because from that point onwards, if you are able to get them to reassign the IP ownership back to you, you would be entirely responsible for all the costs of the filing fees, the patent attorneys, everything to do with that IP and its defence the rights to it would be yours, and any income from it would be yours, but also all the costs associated with it. So it's certainly an option, but it's quite you would need to have some idea of how you were going to proceed before that would usually be an option. The IP itself may also cost you money, depending on what grant it's come from. And from some grants, it may not be an option to buy it back, but it's worth asking about if you're concerned. So that has been a very fast scamper through the academic side of patent, or patents coming out of the academic world. There's a lot I haven't covered, a lot I haven't covered. So really it was a time constraint thing. But if there are questions, do put your hand up, type in the chat box. Louise can help to organise questions. I will just switch off the screen sharing so I can see everybody a bit more easily.
Thank you very much, Joy. I've just posted a question in the chat box from Nick Drury. He's had to just leave, but yeah, he did have this question.
Great, yeah, that's a good question. So Nick says, who is accountable for proving the ideas are new, inventive, and have industrial application? Is that both potential grantor and inventor? So as an inventor and the tech transfer officers as the patent applicant in the industrial situation, your job is to make the case as strongly as possible in your patent application. So that's why using that 12 months is a really good time to really build up that case. In terms of the patent authority themselves, yes, they do appoint an examiner. So they, or several actually, in most cases, and that will be somebody who's expert in the particular area, who will look into whether your application, there's any evidence worldwide that other patents have been granted for your application, whether there's any other public discussion of such an invention. So it's quite an involved process, which is one of the reasons why it takes 2 to 4 years. And there will usually be quite a lot of questions coming back to you as an inventor during that process to clarify items and things. So you are somewhat involved. Is there anything else? Any other questions anybody wanted to cover before I'm aware we're almost out of time. Oh, yes, I think somebody's typing.
Rinjing has a question. And just while he's writing that out, just a reminder for those CARES employees who have access to our intranet, we do have a page on there with some basic frequently asked questions. So I'll add to that from this talk. Maybe I'll grab your slides off you, Joy, because they're really well set out.
Sure.
And update that page. So yeah, we've got a few questions on there that people have already asked.
We'll put the recording up as well.
Yes, I'll do that. Yeah, got a bit of a backlog, but yeah, the talk recordings like this one do eventually make it online.
Yes, we've got a bit of a library there now of. So we've got a question. If I put together a process using open source published components, is that patentable? That's a great question. So this will usually come down to whether, usually the answer would be no. Just combining things that already exist in the public domain, usually the answer is no, that's not patentable. There are some very specific cases where it may be possible, but normally if there's no additional novelty in the components, it's probably going to be difficult to show that as an inventive step. It's still worth asking about if you do feel that it really makes a strong inventive step. But that one usually is challenging. The example that often gets given is you can't patent a cake, for example. You're using, this is a bit of a poor example because you wouldn't try and patent a cake anyway, but you're using ingredients that already exist in the world. You're putting them together using a method that already exists in the world, and that wouldn't be patentable. If your method is new for putting them together, that can be patentable. So it depends a lot on the circumstance. So worth asking about, but definitely you should flag up that those are open source components if you're going with something like that. Anything else anybody wants to ask on? Everybody all right? Great. Well, if no one else has any questions, thank you all very much for joining us. I hope it was useful and interesting. If you do think of any questions or anything that, if you're in CARES, you would like to see on the internet on this that you can't find, do just let Louise know. If there's anything that as I said, it's a huge topic. So if there's anything that I said that you would want another session on, either I or there might be somebody more expert who can help to delve into other aspects for later in the commercialisation series. I know Nick is always very happy to hear suggestions for other topics you'd like to hear about. So do let him or Louise know if that's the case. Right.
Thank you very much, Joy, for that great talk.
Okay.
And thank you everyone for joining.